Another comment here I'd like to make is distinguishing between Islamic law, the history of Islamic law, the legal theory of Islamic law, and the contents. So it's partly a question of perspective, it's partly a question of methodology, and to some extent, of course, also impact the content. When you're speaking about the bare bones of Islamic law, you may not be looking at the history of the matter. You're looking at, okay, this is the evidence that we can rely on to make a claim. How does this evidence fit together to lead to that legal derivation of the law from the sources, the Quran and the Sunnah? Whereas when you're looking at the history, you're not necessarily engaging in the process of deriving. You are looking at how things have already been derived by others. You're looking at the history of that law over time. And what is legal theory? What's the relationship between legal theory and Islamic law? You might think of the relationship between the two as analogous to the relationship between logic and philosophy. And the contents, sometimes you have content that can be analyzed with each of these different approaches. From the aspect of how it's derived, that's Islamic law. From the aspect of its history, how it's developed over time, that's the history of Islamic law. You can look at it from the aspect of its legal theory. What are the underpinning principles that allowed for this type of a derivation? The logic behind that type of derivation, the legal logic, the legal principle logic. So when we're engaging with the material, it's not about what the material is that defines the disciplinary approach. It's about how you are approaching that material. In some classes, you may take a multidisciplinary approach, or you may have a synthetic approach where you cannot easily fit it into one of the disciplines because you're doing multiple things from multiple angles to train people in different ways.